My Lady the Chief Justice, I have 3 questions. They cannot humanly be answered in 3 minutes. I'll suggest I answer them effectively because they are important to this clarification. My Lord Justice Ouko, you've asked, did the High Court or the Court of Appeal provide with exactitude the location of the basic structure doctrine? The answer is yes. And both the High Court and the Court of Appeal said, for you to identify the basic structure, you must look at the history beneath that particular article. Over and above the history, examine the text. Take, for instance, the judiciary. How did it migrate from the judicature to the judiciary? Because before the judiciary, the judicature was a department of the executive. To that extent, therefore, for you to locate the basic structure, you must confine yourself to those 2 fundamental guiding points. I will give you an example. Nelson Havi here is male, is a human being. He was born whole. To use the Bible verse in Genesis 1, and God looked at him and said, behold, a perfect being. I can lose a limb. I'll be given an artificial limb to make myself better. I can lose my sight. I'll be given glasses to make my sight better. But if you dismember me negatively by separating the limbs, the lower limbs and the torso, I will die. And if I'm to be succeeded, then I'll have to be replaced by somebody else, perhaps Nelson Havi II. Essentially, that is the best and simplistic understanding of the basic structure. You will not give me a pig's heart to make me whole. I will live for 1 month and die. So I think to that extent that question is satisfactorily answered. Now, the 4 sequential steps, are they located in the Constitution? No, they are not located in the Constitution. Why are they not located in the Constitution? Let me use myself as the example. I was born, I will die. The manner of my death is not known. Perhaps I will die in my sleep. Perhaps, and to use Professor Githu's words, I will be assassinated because in my status I cannot be murdered, I can only be assassinated. Perhaps I'll die of ailment. So you cannot define with exactitude the manner in which the Constitution will end. Therefore, if you see all these constitutions, the 2010, I believe, I'm not being asked to stop. The 2010, the 1969, and the 1963, they do not provide for the manner of end. But when you look at the 2010 Constitution, you will see it repealing the 1969 Constitution. Those 4 sequential steps, you will trace them from the writings of Professor Nubweze. I can categorize them as primordial, as the imperial creation. You cannot find them within the body. Let me give you another example from the Bible. Trace the genealogy of Jesus in the book of Matthew, Luke, or Mark. You will see it sequentially taken back to Joseph, to David, and finally to Abram and Adam. Beyond Adam, it is the Creator which is outside the being. And it is these basic concepts that must be read into the basic structure, doctrine, etc. And if there is a contradiction that may be introduced into this argument, let's go back to the being. There are 2 principles. One, we came into existence by creation. We'll follow the genealogy up to Adam. The other one, we came here by evolution. Whichever avenue you pursue, you must go back behind the being. And that is what we call the primordial power insofar as the constituent power is concerned. Now, constitutions are peculiar to France and the United States of America. These are the two countries that said will henceforth not be governed by an emperor or the King of England, but will formulate a way in which we'll govern ourselves. We'll set up a constitution with three fundamental organs: the executive, the judiciary, and the legislature, so that these functions will not be left to a monarch. Dr. Smokin Wanjala, you've asked, how did the word altar disappear? Was it deliberate? And what do we do about it? It is my answer that the disappearance of the word altar was premeditated and deliberate. And if you look at the writings of Professor Nobweze, he says the fundamental changes to the Independence Constitution were permissible because of a flaw in the definition of the word altar. So that flaw has now been corrected, so that you will not graft an antelope on me and you say you have a being. That is the intention of the framers of the Constitution. And the court ought not to resuscitate it, because if you do resuscitate it, you will have created the mode of death of a constitution. And that is not what the framers of the Constitution intended. We've gone back to tracing the origin of the constituent power. Does it have a juridical form? The Pharisees asked Jesus, when will we know the end of time? We will never know the end of time, but you will see the signs of the end of time. That is what the teacher said. Now, Aaron Ringera has given clarity to this matter in the case of Njoya versus the Attorney General at page 677. This is what he said. Indeed, it is not expressly textualized by the Constitution. And, of course, it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they will do so only ex abundanti cautela. For instance, I was born here in Kenya. I need not to have an ID or passport, to use the terms of Miguna, for me to be a Kenyan. The ID and passport is there for formality, and it is from that premise that we must perceive the constituent power. Justice Lenaola, you've referred to the Kesavananda case, and you've asked us to create a clarity of where these other facets of the basic structure reside outside 255(1)A to J. Now, that is the reason as to why they have to be basic. When we were in Musingu, Ongoya went to study power mechanics, and because I didn't have greater qualification when I joined high school, I studied art and design. But there is a dichotomy between a diesel engine and a petrol engine. There is the carburetor and the injector pump. And if you doubt this difference, if you attempt to kick it like a stone, you will not travel. It is as simple as that. Now, what is the foundation of a democratic state? The foundation of a democratic state is based upon the social contract, with the trichotomy of parliament, judiciary, and the executive. And if any of those two are fused, then you are obliterating and obscuring that dichotomy. And I can say affirmatively, from my limited learning of the law, that the basic structure must of necessity include the executive, the judiciary, the legislature, and the Bill of Rights. Because for the Englishmen, they said, "Oh, King, no, you cannot rule us like this. We must have the Magna Carta for us to have terms of engagement. For the French and for the American, they said, we must have a written constitution. And for that, the king will not be the legislative. The king will not be the judiciary. And will have rights, rights that you are not giving us, rights that inhere in us as being. To that extent, therefore, those must be entrenched and respected as the basic structure which can be discerned outside 255, 1A to J. I believe I've done my part, or if there's a follow-up question.
Yes, you took your time, 9 minutes.
The time is not of essence here. This is a serious enterprise.
Yes.
The Supreme Court only sits once after 5 years. You did that in an election petition. What is the hurry? Where are we going to?
Yes, thank you.